Welcome. Today is Tuesday, June 9th, 2020. This is a continuation of our a hearing we had on February 11th regarding P.J. Keating's application for a land use license related to the relocation of their asphalt plant on their property in the town of Acushnet. We had the meeting on February 11th. At the end of that meeting, we voted to continue the meeting to a future date, and I think two times at least, probably three times, have had to cancel this hearing because of the COVID-19 situation, and just the fact that we were unable to have a public hearing and unable to meet publicly. And so we're still not meeting publicly, but it really just got to the point where we said, we got to get this done. We got to move this forward. And, we can't keep canceling meetings. While we didn't believe it was ideal to have a hearing like this, on Zoom, particularly given the turnout at the last hearing and the number of people that were at the last hearing, we felt an obligation to move this forward, and this was really the only way that we felt that we could do it. So, again, topic is the land use license that P.J. Keating has applied for regarding their facility on South Main Street. And I just reviewing where we've been. Again, there was a meeting on February 11th. The focus of that meeting was entirely public comment, and we let anybody. There was no hurry to leave that room that night. We let anybody that wanted to speak, had the opportunity to speak, to share their thoughts regarding the land use license, anything they wanted to share. And I think really got to the point that evening where, anybody that wanted to say anything, got the opportunity to say it. So I think at this point, I'd like to move this hearing into the deliberation stage and close the public comment period, because again, I feel we've allowed people adequate opportunity to make public comment. So I'd ask one of my fellow selectmen to make a motion to close the public hearing component of this hearing, land use license hearing.
Mr. Chairman, motion to close the public hearing section.
Motion, Mr. DeRoche. Second, Mr. Gaspar.
The public comment.
Yes.
Portion.
Public comment, yes.
Public comment.
What did we say?
Right.
Public comment portion,
It's
yes.
public hearing, yeah.
Oh, no, we're not there yet. So,
So the motion,
second, any discussion on that?
Mr. Chairman, can you hear me?
Yes, I can.
So the motion is to close the public comment section of the public hearing.
Public comment, say, yeah, okay, yes.
Okay.
Public comment, closing public comment, yes.
I'll make that motion, Mr. Chairman.
A motion and a second. Our further discussion, all in favor?
Aye.
Aye.
Aye. All right, so I think we're at the deliberation. We're at the deliberation, and I've got a town council in anticipation of where we are right now has given me two motions. Has given me a motion endorsing the concept of the land use license, and he's given me a motion denying the land use license, depending on where the group wants to go. So, before we talk about what those motions are, I guess it's let's talk about our feelings regarding the land use license and what we want to do with regard to that application, what action we want to take. And Mr. Gaspar or Mr. DeRoche, whoever wants to go first.
Mr. DeRoche, would you like to go first, or would you like me to go first?
You'd like to, I open the floor to you.
I got a few things, just a few comments, gentlemen, I'd like to read for the record. I think the initial public hearing, we've heard enough, we've said enough. I know that we've seen enough, or at least I have. So I just want to state a few things. Asphalt fumes are known toxins. The Federal Environmental Protection Agency states that asphalt processing and asphalt roofing manufacturing facilities are major sources of hazardous air pollutants. Exposure to these air toxics may cause cancer, central nervous system problems, liver damage, respiratory problems, and skin irritation. That's by the FDA, words from the FDA. Communities faced with an asphalt plant proposal should push for setbacks from residencies and community buildings site-specific health-based air pollution modeling and monitoring, enclosures for loading zones, and preferably a zero-emission asphalt plant with total containment of air pollutants. Precautionary decisions place the highest priority on protecting health and the environment and help develop cleaner technologies and industries with effective safeguards and enforcement. Government and industry decisions should be based on meaningful citizen input and mutual respect, the golden rule, with the highest regard for those whose health may be affected and for our irreplaceable natural resources, not for those with financial interest. Uncompromised science should inform public policy. Decision-making by government, industry, and individuals must include an evaluation of alternatives and the choice of the safest, technically feasible solutions. That's my comment, I guess, to whoever's going to be hearing this now and in the future. There's some known facts. I guess, Mr. Chairman, we know how this all went. In 2017, we had a public hearing. I have a newspaper advertisement here. I'm not going to go through it. Everybody's familiar with it. The public hearing with the Board of Health, stressing from our residents the opposition to this plant being moved to the forward of the site. And then they came back. It was Mr. Kevin Eukin, a representative, PJ Keating, says we'll come back in 30 days with alternatives, proposals. That never happened. Next thing we know, the plant's being moved to the front of the property. No other input from management, at least not with this board, Board of Selectmen, which are authorized to issue a land use permit. I want to bring to everybody's attention, for those people at home and also PJ Keating, because this is the lack of regard towards our public, towards our town officials, towards our state officials. And it's right here in a basic requirements. It states, general requirements for plan approval. General A, no person shall construct, substantially reconstruct, alter, or substantially operate any facility subject to the requirements of 310 CMR 7.02, 4, or 5, unless an application for a plan approval has been submitted to the Department of, and the plan approval has been granted by the department. Procedures and contents of the application for plan approval can be found at 310 CMR 7.02, 4, and 5. I guess if somebody of my caliber can find something this easily, and I know that they claim that they were, after some subsequent letters to DEP, that they claim that they were exempt and they looked for all the exemptions that they could find. What I just read to the public, to our residents, and to you gentlemen, my colleagues, is in black and white and easy for everybody to find. These people are supposed to be professionals that understand the rules and regulations that they operate that quarry. I don't understand the ignorance of this company that would just take that facility, move it to the front without going through the proper protocols. DEP is now, after few weeks, thankfully, and I thank the representatives of DEP, they actually cited them for this clause. I guess it was in PJ Keating's management minds, the so-called saying, it's easier to ask for forgiveness than it is for permission. For the record, for anybody who's going to ultimately make a decision after the Board of Selectmen, for the record, I hope that anybody that review this case and review this hearing understands that this cannot allow to happen at any quarry, anywhere. You can't let somebody take action, move harmful toxins closer to residencies. We have a council on aging, not even a quarter of a mile from the front of that facility, with no disregard. They didn't care about anything else other than themselves. Because if they did, they would have came to this board and had a rational conversation and said, what can we do to move this plant to where we want to move it to, and what would you like to see? In my opinion, that never took place. I would have thought that would have taken place after our initial public hearing. It did not. I asked the DEP, any judge, any mediator, arbitrator, anybody to please acknowledge that it's not right that somebody took a plant of this magnitude with the toxins that they release and moved it to the front and feel that they're going to get away with it just because it's already there. I really hope that everybody that's involved in this process takes a hard look at this and says, we cannot let this happen in the town of Acushnet, because if it does, you will set precedents, and it will happen in other places in the Commonwealth of Massachusetts and other states around the nation. So I plead to anybody making decisions to please consider this blatant disregard to the public health of our community. Thank you, Mr. Chairman.
Thank you, Mr. Gasper. Mr. DeRoche. Mr. DeRoche?
Thank you, Mr. Chairman. You know, this whole process started on February 12th, where we held the public forum at the middle school. And at that time, I was uneducated about the way the quarry has been operated and how the town has been dealing with it over the years and the citizens' concerns. And this last 3 months has brought me really in full circle and to see what has been done and get an understanding of things. So here we are tonight to make a decision on granting this land use license, which as a citizen should know, concerns the filling of the asphalt plant, filling of the tanks of the asphalt plant so they can produce asphalt. Listen to Mr. Gaspar's comments, they're spot on. We've dealt with legal, town council, dealt with Fire Chief Kevin Gallagher, who's been point man on this whole operation from the beginning. I was very distressed to see the way the quarries handled this up to this point. And hope our actions tonight can get us to resolve the matter in a professional way, keeping the concerns of the citizens, their health and well-being forefront, and proceed and have a mutual understanding from this point on with the quarry. Those are my comments.
Mr. Roche. So I guess I'll conclude the comments, and I get the tone of where we're going. You know, this is something, is early public meeting I attended, you know, 2.5 years ago, 3 years ago, was PJ Keating rolling out this plan for moving the asphalt plant to the front of the property. And, you know, the neighborhood really came together in opposition to that plan. And I you know, was at that point really disturbed by what I heard from the neighbors of the PJ Keating quarry, and you know, the conditions that they've had to live with surrounding the quarry. I mean, their homes, their vehicles, their lives are covered in dust all the time, sound at all hours of the night, trucks up and down the road, and just, you know, the term that I think describes PJ Keating best is tone deaf. I mean, they just don't get it. They don't hear. They don't listen. They don't seem to care. They operate with a complete disregard for their neighbors. And you know, I early on got a tour of the PJ Keating facility, and you know, was to talk to the neighbors. Went to the facility and saw the piles of materials on the PJ Keating site, and looked, and I go, that's the problem. They've got, you know, materials stacked up to heaven that's just, you know, gonna blow those materials all over the neighbors, and you know, did not seem to be any system in place for controlling that or prevent that from happening. So, you know, just story after story from the neighbors at the, you know, that initial public session 3 years ago. I don't know if that was a formal hearing or that was an informational meeting or what that was, but, you know, the neighbors came out then, the neighbors came out, you know, on February 11th at that meeting, and just heard stories, and just, you know, I think the most recent example, while we're living in this, while they know we're talking about the soil permit, while they know we're talking about their land use license, is I'm going to say this was 3 weeks ago, 4 weeks ago on a Saturday, 6:15 a.m. on a Saturday morning, PJ Keating decides that's a good time to run a jackhammer on their site, and that sound carried forever. And the neighborhood once again up in arms over 6:15 on a Saturday. Really, does that need to be done now? So it's just more evidence of a complete disregard for the neighbors. And we initially were led to believe that we implored PJ Keating to find another spot for this asphalt plant, and they looked at putting it up on the road. I multiple times asked them, there's got to be you got a huge piece of property, move it back, find a way to move it to the back of the property. And very honestly, never heard a good reason as to why that wasn't possible, other than they were, trying to save gas on their vehicles, that the vehicles would have to travel an extra mile to the back of the property. And, it was a cost saving measure for them. So really no concern for the neighbors, more, we need to cut our expenses, and that's why we're doing it. So, but we were led to believe there was nothing, they could get a building permit, they complied with zoning, nothing they could do about it. And then, oh, wait, we need a land use license, which was shocked that they weren't aware of the basic requirements of doing what they need to do to manage their business. But they need a land use license from the Board of Selectmen. And, I'll cut to the chase. If I've got authority over this, I'm not inclined to grant them a land use license. I don't think that asphalt plant belongs at the front of the property. I don't think PJ Keating over the years has shown any good faith, any attempt at trying to be a good neighbor. And I suspect with the asphalt plant in the front of the property, that's going to continue. So I'm not in support of granting this land use license. I would suggest that the board deny that. End of my unprepared comments.
Mr. Chairman, I couldn't agree more.
Mr. DeRoche, you also, it feels like the mood is we're going to deny this. Is that, again, I came in with two motions. Should I read one of them?
Well, I think we have a motion to discuss.
Well,
It should be presented, and then we should vote on it.
And again, two motions were distributed. Let me read this one. And this goes on a bit, but I move that the board.
Mr. Chairman?
Are we ready for this or no?
Mr. Chairman?
Yes. Go ahead, Mr. Gasper.
You alluded to that you're in favor of a license denial, so I think, and I also stated the same facts for many reasons, both tonight and in previous meetings. So I would go with the alternative motion number 2.
That's right. I was going to read that right now. I was going to read that right now, Mr. Gasper.
License denial, please.
That's correct.
Read that.
Please proceed, Mr. Chairman.
Reading this motion, I move that the board deny PJ Keating's application for a new land use license for the property located at 72 South Main Street on the grounds that the applicant has failed to demonstrate that the issuance of the license is in the public's interest. I further move that the board adopt the following findings in support of its decision. Number 1, PJ Keating, hereinafter the applicant, is the owner of the property located at 72 South Main Street, Acushnet, Massachusetts, aka the property. Point 2, the applicant operates on the property a quarry from which it mines crushed stone and gravel, conducts sand, gravel, and stone processing, and operates a plant that produces hot mix asphalt. Point 3, the applicant is the holder of a license dated July 11th, 1995, issued to Tilcon Mass, Inc., pursuant to Massachusetts General Laws, Chapter 148, for the storage of 88,000 gallons above ground, 12,000 gallons underground, of AC-20, diesel fuel, number 2 fuel oil, waste oil, motor oil, and gasoline. Point 4, on or about November 11, 2019, the applicant filed an application pursuant to Mass General Law, Chapter 148, to amend its license so that it may relocate 3 vertical above-ground liquid storage asphalt tanks located on the property. I'm sorry, my thing just located on property. Point 5, during the pendency of this application, the applicant relocated the hot mix asphalt HMA plant on the property and reused the 3 existing vertical above ground liquid asphalt storage tanks. 6, tank 1 was installed on the property in 1998 and has a 20,000 gallon capacity. Point 7, tank 2 was installed on the property in 1998 and has a 20,000 gallon capacity. Point 8, tank 3 was installed on the property in 2013 and has a 30,000 gallon capacity. Point 9, the above ground storage tanks were previously located on the easterly portion of the property and away from residential homes and public ways. Point 10, applicant has relocated the tanks to the westerly portion of the property near residential homes and with approximately 100 yards of South Main Street, a public way in the town of Acushnet. Point 11, applicant initially stated that approximately 6 to 12 trucks will visit the HMA plant and above ground storage tanks every day. We have since received information that the truck traffic may be as high as 100 trucks per day. Point 12, applicant stated that trucks loading and unloading on the property will be equipped with standard backup noise alarms. Point 13, applicant initially stated that trucks would be required to sit and idle at high idle to allow for the pumping of liquid asphalt. 14, subsequently, applicant stated that the high idling of trucks is not required because product will be drawn from trucks via a pump into either the storage tanks or directly into the production process. Point 15, the board requested that the applicant provide additional documentation to the fire chief regarding the fire safety, fire prevention, and fire protection engineering. Point 16, on May 20, 2020, the applicant provided to the fire chief the requested fire safety report. Point 17, as of the date of this decision, the fire safety report is awaiting peer review by a third-party consultant recommended by the staff at the Department of Fire Services. As such, the board does not yet have the third-party consultant's findings. Point 18, on April 28, 2020, the Massachusetts Department of Environmental Protection, Southeast Regional Office, Air Quality Permitting Section, Mass DEP, issued a determination letter that the proposed relocation of the HMA failed to meet the criteria for 310 CMR 7.02 2B27 exemption from plan approval and was thus subject to the requirements of 310 CMR 7.025 comprehensive plan application CPA. Mass DEP determination letter also states that given the Mass DEP findings identified in this document, the facility cannot operate the relocated hot mix asphalt drum plant and hot oil heater until such time as it has demonstrated that it meets the requirements of 310 CMR 7.02 2B27 or it has obtained a modification to plan approval number 4P09023 by submitting and receiving approval of a non-major air quality plan application in accordance with 310 CMR 7.025. Point 20, on June 2, 2020, the Mass DEP issued a second determination, here and after the second letter, stating that air emissions associated with new equipment at the relocated HMA plant have not previously been evaluated in accordance with 310 CMR 7.02. Point 21, the second letter also states that additional sound mitigation measures at the relocated HMA plant may be required to comply with the Mass DEP noise policy. Point 22, the second letter also states that the applicant's submissions to Mass DEP failed to address nuisance conditions other than noise that could cause or contribute to a condition of air pollution. Point 23, as of the date of this decision, the applicant has yet to satisfy Mass DEP criteria in order to operate the HMA plant. Point 24, the board has conducted a public hearing session on the application. At the session, residents of the nearby residential neighborhoods appeared and expressed their opposition to the application. Point 25, based on these facts, the board finds that the storage of liquid asphalt in the relocated above-ground storage tanks is not in the public interest because it will increase the threat to public health, safety, and the environment. Point 26, allowing the storage of liquid asphalt in the proposed location and configuration will increase the threat to public health, safety, and the environment because if there is a release of liquid asphalt, the impact will be greater on the surrounding residential neighborhood. Point 27, allowing the storage of liquid asphalt in the proposed location and configuration will increase the threat to public health, safety, environment. I read that. Sorry. Point 28. Hold on, is that in there twice? That might be in there twice. Point 28, the storage of liquid asphalt in the relocated above-ground storage tanks will contribute to additional noise pollution because trucks will be required to operate closer to the residential neighborhood before loading and unloading liquid asphalt. Point 29, the storage of liquid asphalt in the relocated above-ground storage tanks will contribute to additional noise pollution because trucks will utilize backup noise alarms closer to the residential neighborhood. Point 30, the storage of liquid asphalt and relocated above-ground storage tanks will contribute to additional dust and environmental pollution in the surrounding residential neighborhood due to increased truck activity. Point 31, last one, the applicant has failed to satisfy the board that the storage of liquid asphalt in the relocated above-ground storage tanks is in the public interest and has failed to address sufficiently the possible detrimental effects on the surrounding residential neighborhood. With that done, Ms. Hebert, you had your finger up and I didn't see it because I was reading.
Okay, no, so I think you should read 27. It is different from number 26.
27 is different. Let me read 27 then.
Thank you.
Allowing the storage of liquid asphalt in the proposed location and configuration will increase the threat to public health, safety, and the environment because if there is a fire or explosion, the impact will be greater on the surrounding residential neighborhood. I'm sorry, it started the same as the prior two. I felt like I was being redundant.
That's okay.
So that's the motion. Could I get a motion? Well, that is the motion. I will make that motion. Could I get a second? Could I get a second? Mr. Gaspar, you muted. Mr. DeRoche, could I get a second?
Second, I'm sorry, second, Mr. Chairman.
Second. Further discussion? All in favor of passing the motion as read? All in favor? Aye.
Aye.
Unanimously, aye.
Aye. With no further business to come before us, could I request a motion to adjourn this public session? Mr. Gaspar, go.
Mr. Chairman, I just want to make sure that this is the final. I think we could close the public hearing now, make a motion to close the public hearing for BJ Keating.
Yes, we need to close the public hearing. Agreed. Yeah, we didn't do it right last time because we didn't get good instruction. Get a motion to close the public hearing. Second, Mr. DeRoche.
I'll second.
Second. All in favor?
Aye.
Aye.
Aye. Aye. And do we need a motion to adjourn this meeting? I think we're done, right?
Motion to adjourn.
I'll second.
Second that. All right. All in favor?
Aye.
We are adjourned and the public hearing is closed. Thank you all for coming.
Thank you.